allow me to introduce our two great speakers today. Our first speaker is Dr. Anne-Laine Farrar, who is a Vice President in the Antitrust and Competition Economics practice of CRA and Adjunct Professor at Northwestern University School of Law. She specializes in antitrust and intellectual property matters, especially where the two are combined. Dr. Laine Farrar has advised clients and provided economic testimony around the world. She has provided economic submissions before several regulatory bodies in the US, Europe, and China. In 2018, Anne was awarded Economist of the Year by the Global Competition Review. Our second speaker is Richard Stark, who is a partner in Cravath, Swaine & Moore LLP's litigation department. His practice emphasizes intellectual property, antitrust, and other technologically intensive litigation for both plaintiff and defendants. For almost 30 years, Rick has litigated patent infringement and antitrust cases in areas including pharmaceuticals and biotechnology, software and computer systems, microelectronics, automotive engines, and chemical processes. If you have questions, again, please do not hesitate to post them in the Q&A area on your screen. Without further delay, Anne, the floor is yours.
Thank you. Just a quick roadmap for where we'll be going today in our discussion. We'll be focusing on the debate between license to all and access to all, and I'll define that a little more definitively in just a minute. We're going to talk about what the arguments are. Then Rick will go through the principles of patent law, patent licensing, SDO policies with two examples, ETSI and IEEE, and then some legal analysis, and then I'll come back again to wrap up our discussion with economic issues. Next, please. So the arguments are in one camp in favor of license to all, are people who argue that every single entity, every firm, all along the chain of production, from the smallest of the components all the way to the end products, actually need a license to every single patent that is essential for the production or compliance with a technology standard. So a standard essential patent, SEP, is one that covers technology that must be used in order to be compliant with a standard. And this camp argues that when entities holding SEPs commit to an SDO to license those SEPs on fair, reasonable, and non-discriminatory, or FRAND terms, that commitment implies that the SEP holder will grant a license to anyone who asks wherever they lie within the production chain. On the other side of the debate, or in another camp, are those who argue that licenses themselves are not necessarily needed, but rather access. And so it's access to all that's important to ensure, rather than a specific license for everybody. And here, this camp argues that not every single entity, not every single firm along the production chain actually needs a license to the SEPs, but rather, as long as access is allowed, that SEP holders can choose which link within the production chain, be it components or end products, to license, and the others can have access through without a specific license. Next. At the root of this debate between the two camps is really an argument over how much should be paid in royalties for standard essential patents. And so the simple math that you see on the screen is really just to illustrate the point that when you lower the royalty base, the revenues upon which you're calculating the royalties, you lower the royalty amounts paid. And so moving from, for example, an end product license down to a smaller component license will shrink the revenue, the revenue base, and therefore the royalties. And so that's sort of the background of these issues. Next. And I will pass the mic over now to Rick to walk through the various legal regimes that play an important role within this debate.
Thanks, Anne. And I should note at the outset, and I'm sure I speak for Anne as well when I say this, thank you very much to 4IP Council for having us. And the views expressed by both of us are our personal views and not the views of our firms or our clients. And with that, I'd like to pick up from Anne's introduction and dive into the legal issues. And what we're really going to be talking about in this presentation is the question of, is it accurate to say that FRAND commitments, broadly speaking, require license to all? In other words, if I made a FRAND commitment, must I license anyone who asks for a license and for all purposes? Is that what sort of FRAND generically means? And the answer that we ultimately come to is no. FRAND does not generally mean that, or more precisely, it really depends. You have to look at the specifics of the FRAND commitments in question, because FRAND commitments are contracts ultimately, at least in the at least from the American law perspective, which is where I'm coming from, and thus you have to look at what the contract actually says to know what it means. With that, I want to go through some background of patent law and licensing to try to establish a common ground, enable us to discuss some of the more advanced topics. And some of this will be old news to some listeners. It may be new news to other listeners. So we'll go through some of the basics just to, in a quick way to get grounding. So the first, of course, question is, what is a patent? And really, fundamentally, it is a negative right. It's a right to ask someone not to do something, basically. In US law, it's a grant from the US government to the inventor of an invention of the right to exclude others from making, using, offering for sale, or selling, or importing his or her invention. Or you might say it's really, a patent is really the right to potentially assert your patent and sue for remedies for patent infringement. It's not, importantly, a patent is not a right to use an invention. In other words, if I have a patent on a particular claimed invention, my having a patent doesn't actually entitle me to practice that invention necessarily, because my invention might in fact infringe somebody else's patent, and I could still have legal issues even though I have a patent. I don't have to assert my patent against anyone. Likewise, I don't, absent any other agreements or contracts, I don't have to license anyone to my patent. If I just own a patent, I haven't signed any other agreements or commitments. So all a patent is a right that you can assert in a court in countries around the world, and seek to get an injunction or seek to recover damages. If you wish to enforce your patent, patents are issued around the world by each national government, and you'd have to have a patent in a particular country, take it to the courts of that country, and assert your rights. To get relief for patent infringement, the patent holder has to prove infringement, which is governed by what we in the United States call the all elements rule, meaning that all elements of the claimed invention must be found in the accused product in order for infringement to be established. There also are a host of defenses that an alleged infringer can raise, and the burden of proof would be on the alleged infringer, but ultimately the patent holder has to prevail on essentially all issues, has to prove infringement, has to defeat all the defenses, and then has to prove its entitlement to particular remedies sought in order to get relief in court. Next, please. So now I want to talk a little bit more about the patent infringement analysis. This is a very quick slide to summarize what's a fairly complex area of law, but fundamentally, when you look at a patent, you find that the intellectual property right that is defined and protected by a patent is expressed in what we call claims. They are little, well, can be long or short sentences, essentially, at the end of a patent, or in some countries at the beginning of a patent, which specify exactly what is claimed and or exactly what the invention is that's protected by the patent. And each claim is like a logical and statement. So it consists of a number of elements, or also called limitations. And each one of those elements or limitations has to be found in a product altogether in order for there to be infringement. So then you have to take a claim and compare it to an accused product and see if all the elements are present. So that's illustrated on this slide with a patent that we show on the left here. And the little sort of jigsaw pieces are meant to symbolically represent claim elements or limitations, which are just generically labeled as A, B, and C. That could be particular chemicals or steps in a process or aspects of a circuit. Those are the kinds of things that could be claim elements. The concept here is the patent shown on the left claims A and B and C altogether, A, B, and C. So if we then look on the right side, I've illustrated 3 different widgets, and widget is just, at least in on our side of the pond in America, is just a name, a cutesy name for any old product or device, a thing. So widget number 1, the box at the top on the right there, is shown as having puzzle pieces A and C. So if we compare that to the patent, it's missing B, so that would not infringe, indicated by the red X symbol there. So there's no infringement as to widget 1, so the patent holder would have no rights against widget 1. Widget 2 has A, B, and C, so there's infringement. If this were an infringement case, the patent holder would establish infringement, and you'd move on to other potential issues in the case, but at least infringement would be established, and the patent holder basically has then rights to assert against widget 2. Widget 3 is an interesting example for the rest of this presentation. So widget 3 is a device that has A and B and C and D in it. So it's got all of the things claimed in the patent, plus more. It has the element D in it as well. And the important thing to note is that also infringes. Having extra things, extra stuff in a product does not avoid infringement. There's a question, it's a very strict legal logical question when you're looking at infringement. If the patent claim is limited to A and B and C, then the question is, are A and B and C present in the product? Additional stuff in the product does not avoid infringement. We can go to the next slide, please. Now, this slide illustrates the idea of a chain of production. So in a very simplified fashion, we show producer 1 at the top here. Producer 1 produces widgets with A, B, and C puzzle pieces. So these widgets would infringe the hypothetical patent from the prior slide. And producer 1 sells its widgets to producer 2. Producer 2 uses the widgets then to produce devices, which are illustrated here as having elements that correspond to A and B and C, same as in the hypothetical patent, and more elements, D, E, and F as well. But as discussed on the prior slide, the presence of elements D, E, and F don't matter for infringement. The infringement question with respect to the hypothetical patent from the prior slide is only, are elements A, B, and C present? And they are present in the devices made by producer 2. So producer 2's devices would also infringe the hypothetical ABC patent. And I'll also mention that the producer 2 then sells its devices to end users. End users then have and own and use devices, and end users potentially also could infringe, because use of a device that has A, B, and C in it would also infringe our hypothetical patent. We can go on to the next slide, please. So this slide goes to the question of what is a patent license. Patent license is a contract. That's all it is a contract which fundamentally says patent holder will not sue the licensee for patent infringement, under certain conditions. It may be a fairly complex patent. It may be multiple parts to it. One could enter into a license for a particular field of use, for example. I could license someone to make very specialized watches that are only used in auto racing, for example. They might have other uses, but I might license them only for auto racing. So you can have conditions on a license, but basically you should think of a license as a contract that says the patent holder won't sue the licensee, and there's then going to be consideration that flows from the licensee back to the patent holder. Normally that's royalties. It could also be other consideration, but for the moment, we'll just think of it as royalty payments. And so that's essentially what a patent license is. And in the litigation context, a license is a defense. It's a defense to infringement. So if the patent holder were to sue producer one, who's got a license in this picture, producer one would say, hey, wait a second, you licensed me, I have a license. Or in a maybe more realistic scenario, patent holder perhaps sold its business or sold its patent portfolio off to somebody else, and that somebody else, through whatever circumstances, ended up litigating with producer one, and producer one again would be able to say, wait a second, I was licensed. So your patent infringement claim, at least as to the licensed patents, doesn't fly against me. So that's what a license is in a nutshell. A couple of points about what a license is not. Licenses are often misconceived by people who are new to this area. A license is not a secret formula. It's not the secret sauce that allows you to start a business or to successfully produce something, or that it's not the knowledge base that you need. It's not equipment or materials or any of those things. It's all it is a contracted for defense against a claim of patent infringement. And so you should think of it as a fairly narrow thing. So what's illustrated here is producer one is granted a license by the holder of our hypothetical patent. So they have sort of a box around them, a shield, if you will, against being sued for infringement of the hypothetical patent. And that makes sense because the patent holder could assert the patent against the widget with A, B, and C. And they might also assert their patent and then sign a license with producer one. Now, if we go on to the next slide, this just briefly illustrates the idea that the patent holder of our hypothetical patent could instead of asserting the patent against producer one, could assert it against producer two, because producer two's devices, as previously discussed, also infringe the hypothetical ABC patent. And producer two might enter into a license with the patent holder, and that would also make perfect sense. So that's just another scenario, and that illustrates an important point, which is that absent any other agreement limiting its rights, a patent holder fundamentally is free to choose whom to assert its patents against. So it could choose to assert against producer one or producer two, or even the end user. That's entirely a choice that is left by patent law to the patent holder. Next, please. So what about this scenario? The question may arise, well, could the patent holder grant licenses to two levels of the production chain? And the answer is yes, they could. But in practice, they probably wouldn't choose to do this because there's a doctrine in patent law, it's a judge-made doctrine in the United States, and it also exists in many other countries around the world, in some cases by statute, called patent exhaustion. And the idea here is the patent holder is entitled to get its recovery once against an infringing product. So if the patent holder asserted its patent, signed a license, or got a court recovery or what have you against widgets made by producer one, those widgets, once the royalty is paid, would then enter the stream of commerce and be free of the patent rights for the ABC patent, because the idea being that the producer paid up. So those widgets are then free of the ABC patent, at least, not all patents, but at least the widgets that are sold under license, under royalty for that patent are free of that patent once they're sold and paid up. So then it would not be permissible for the patent holder to collect again when the widgets are incorporated into devices by producer two. So for this reason, it really would not be in the interest of, and would not be likely something that the patent holder would agree to license both levels of the chain. They would pick the level that's optimal for them, the level that's consistent with industry practice, and so on. So we can go on to the next slide. Having covered in whirlwind fashion a little bit of background on patents and patent law and licensing, and I want to introduce some quick background on standard essential patents, or SEPs, and FRAND, fair, reasonable, and non-discriminatory terms and conditions. First, we need to have a little understanding of standard development organizations, or some people refer to them as standard setting organizations. And I prefer the term standard development organizations because really what many, if not most of these organizations do is essentially an industry-wide development effort. They sponsor an industry-wide development effort in which a number of firms cooperate by contributing technological advancements and agreeing on the shape and specifications of a standard for particular products or particular aspects of an industry. And so there's a lot of actual work, innovative work that goes on in standard development organizations. And it's not merely an issue of just picking, we're going to pick this existing solution or that existing solution or this patent or that patent, and voila, that's our standard. There's actually innovative, creative development work that goes on in here. There are many standard development organizations, and this chart is just an illustration that I found in a publication, in a paper that's mentioned at the bottom here. And it lists on the right side a small fraction of standard development organizations that exist in the world. There are many, many, many. This is just a few of them. And even the relative few listed on the right side of this chart, you can see produced something around 25,000 standards in recent years, 2012, 2013, 2014, for example. So many standards are being produced in the world, and there are many SDLs. So that highlights sort of the importance of the issue, but also the importance of looking closely at the facts, because the facts of each individual situation may differ. And it may be different when you're talking about autos or telecoms or personal computers or building materials. Any industry you can think of probably has industry standards, has different industry standard organizations, and therefore potentially different rules that apply. Next page, please. This slide then illustrates the general sort of work that goes on in developing standards. And what I'm illustrating here is there's sort of two streams of work, simplifying greatly. You can think of two major streams of work that go on. So on the left side are a number of innovator companies, innovators 1 through innovator N, and they could be any companies in any industry, and they will be working on developing technologies to solve particular problems, which they then contribute to the standards development organization, pictured at the top center. Those technical contributions then are debated and vetted, worked on, developed within the organization, and eventually contribute to standards that issue from the organization, which are shown on the upper right. And those are standard specifications that will indicate all the details of what a ultimate producer needs to do to comply with the standard. So implementers then would take those standard specifications illustrated in the upper right and use them as part of their production process to produce products. At the same time, as they're working with the standards development organization, innovator companies will also be applying for patents. So they develop new inventions, new innovations to try to solve the problems that standard development organizations are directed to, or other related problems. They'll make patent applications to patent offices around the world, and the process within each patent office will grind through and eventually produce patents. Patent applicants may be successful on some, not successful on others. The patents that issue may bear more or less resemblance to what was applied for, and may issue, frankly, much later than the specifications from the standard setting organization, standard development organization. And at the end of that process, each innovator may or may not have a number of patents, and those patents may or may not read on, that is, to claim the same subject matter as standards specifications that issued from related work. And this is where standard essential patents come in. And some of the patents that are issued may later be determined to be standard essential patents. We can go on to the next slide. So now we come to the question of what is a standard essential patent. Recalling from the prior slide, we have the standard setting process that results in standards and the patenting process that results in patents. When you then sit down and look at the patents that have issued, you may find that the claims of some patents read on an aspect of a standard such that it's not possible to practice a standard without infringing. And if you have a patent like that, that's a patent that is called essential. That's a standard essential patent. The various standard development organizations have policies or rules regarding SEPs, or more broadly, intellectual property rights, largely SEPs. And typically they'll require disclosure when it's known or that you have a patent that is essential or may be essential. You're likely to be asked to disclose that to the standard development organization. And if you have a standard essential patent, you're likely to be asked under the policies and rules of the organization to make clear what your stance is on licensing. Typically or often, you may be asked to agree that you will grant licenses on fair, reasonable, and non-discriminatory terms and conditions, or FRAND. So that, in a nutshell, a bunch of background gets us to what are SEPs and what is FRAND. We can go on to the next page. So let's look at a couple of examples of SDOs and their patent or IPR policies. And the first one that we discuss is Etsy. And Etsy's IPR policy expressly states a couple of objectives. One is to reduce the risk that a standard could be unavailable. And the other is that IPR holders should be adequately and fairly compensated. So you might ask yourself, what's this risk that a standard could be unavailable? Well, the idea there is industry participants have gotten together and worked through Etsy or related organizations to produce a standard, and hundreds of thousands of hours have been put into this. A lot of resources have been committed to this. If one or multiple participants in that process also got patents at the same time, and as would be their right as patent holders, chose not to license anyone, just to keep the patent to the rights to themselves, you could suddenly find your development effort coming to a screeching halt because no one's granting anyone licenses, and therefore the standard might be quote unquote unavailable. So the policy seeks to avoid that result where patent holders simply don't grant licenses at all. And this ties into the notion of access to all. Really, what this policy is talking about is that the standard is accessible. It can be practiced, and it's not just rendered unavailable. And the second goal, of course, that IPR holders should be adequately and fairly compensated. What's the issue there? Well, the idea is, of course, on the other end of the spectrum, if the standard's not unavailable, it's available, it's promoted to everyone, it's standardized, there's wide distribution, and potentially many users of patented technologies. How do we ensure that those who have the patent rights, those who contributed to developing the technologies, aren't just giving it away if that's not what they choose to do, that they do have the ability to be adequately and fairly compensated. Those are objectives. Then there's a multi-page policy, which I won't get into gory detail on, but in a nutshell, the owner of a standard essential patent is asked to commit that it is prepared to grant irrevocable licenses on FRAND terms and conditions to at least the following extent. And then the policy says there are more elements to it than this, but the essential part of it is that the SEP holder is prepared to grant licenses for the manufacture, and that's a defined term, of equipment, and that's a defined term. And specifically, equipment is defined as any system or device fully conforming to a standard. And within the ETSI realm, fully conforming is something that's also defined within the standards. There are conformance tests, for example, so equipment can be tested to see if it conforms to the standard. And equipment means infrastructure or handsets, the handheld devices, for example. It's not components, it's actual devices that actually perform the standard and satisfy the conformance tests. If we go on to the next page, a few things about what the ETSI IPR policy does not do. It in fact says nothing about who should be licensed. It does not require licenses to the entire production chain. It simply says nothing about that. It does not require any particular number of licenses. It does not require identify any particular entities who should be licensed. Instead, the scope of the ETSI FRAND commitment is defined in terms of subject matter. Licenses for the manufacture of fully conforming devices and systems are what the SEP holder is asked to commit to. Moving to the next slide, another organization that we discuss is the IEEE, which has a rather different policy. And the IEEE asks SEP owners to give letters of assurance, either that they won't enforce their SEPs or that they'll make available licenses without compensation or under reasonable rates, which is a defined term that I won't get into. But the scope is important. They're asked to make available licenses to make, have made, use, sell, offer to sell, or import any compliant implementation that practices the essential patent claims, and so on. And compliant implementation is a defined term in the policy, and it means any product, e.g. component, subassembly, or end product or service that conforms to any mandatory or optional portion, I underscore, of a normative clause of an IEEE standard. So this is rather different than the ETSI policy, which spoke about fully conforming equipment. Here, the IEEE policy specifically calls out components and calls out conformance with portions of an IEEE standard. Next slide, please. And just very briefly, IEEE policy also, like the ETSI policy, does not say whom to license specifically. It doesn't expressly require licenses to the entire production chain, but it does have a different scope, as I just mentioned. On to the next slide, mindful of the time. Legal analysis, again, coming back to the question that I started with, is it accurate to say that FRAND commitments, generally speaking, require that licenses be granted to all comers? And to the argument that, in simplified form, is made by proponents of license to all, are SEP licenses really needed by all? Legally speaking, no, they're not. There's no law that says that anyone has to sign a license. It's not a prerequisite, legally speaking, to carrying on one's business. It's rather whether you take a license or don't take a license is a matter of risk management, which depends on the likelihood of patents being asserted against you, and a whole bunch of factors that one would consider in the real world. Practically speaking, is there a need for everyone in the chain of production to have a patent license? And again, the answer is no, because a patent license does not provide you with technical know-how. It doesn't provide you with the ability to manufacture a product. And in terms of what's necessary to comply with the standard, the entire point of a standard is that that's all written down and specified in the standard specifications. So that's publicly available to those who wish to practice the standards. So there's no legal or practical strict requirement that anyone take an SEP license. Do SDO policies generally require licenses for all entities? And the general answer would have to be no, because FRAND commitments are contracts. One would have to look at the specific contract and the specific factual context to understand what is meant by that contract, what has been the practice in the industry, for example, what do the terms used in the contract mean to industry, for example. And you have to look at this individually, organization by organization, and based on the whole factual context. We just took a quick look in prior slides at ETSI and its IPR policy versus the IEEE and its patent policy, and neither contains an express requirement to license everyone in the production chain, but they do have differing scope of their licensing commitments, and therefore one would, I submit, reach different conclusions on each of those as to whether they require licensing components, for example. ETSI, as we've argued in our paper, does not require licensing up and down the chain of production, and IEEE hasn't been litigated, but one might reach a different conclusion. It certainly has a different scope to it. And lastly, the question arises on the next slide. Does competition law require licenses to all comers? And in brief, the answer under US law anyway is no. There appears to be no theory under competition law in the United States anyway that has been presented to date and reached the conclusion that licenses are required up and down the production chain. There's a summary here, but in the interest of time, I'm going to skip on past that and pass the mic to Anne to talk about economic issues.
Thank you. So next slide, please. Yeah, here we go. So in addition to considering all of the legal aspects of this debate, we also need to keep in mind how they impact people's incentives, and particularly the firms that are participating in standard development efforts, how it affects their incentives to both participate in SDO efforts, to invest in R&D and develop new technologies. And when we're talking about for-profit entities participating in standard development organizations, and most by and large members are for-profit entities, some others on the fringes, we're talking about return on investment, ROI. So this is essentially a cost-benefit analysis. On the cost side, in addition to flying engineers to meetings all over the world for several years in order to develop a new technology standard, innovators also have to invest in new R&D in order to develop new inventions to then contribute to the standard. And on the downstream implementer side, in addition to the meetings, et cetera, they invest in turning those several hundred-page technical specification documents into commercial products that customers are willing to buy. Both entities are only going to incur these costs if they believe, if they anticipate that the benefits will outweigh them. And so the benefits in terms of return on investment are profits, and there are two ways to earn profits through technology standard setting. One is to license standard essential patents or other related patents, commercially important patents that read on products implementing a standard. And the other is to sell products and services that are standard compliant. Vertically integrated firms can access both these sources of profits, but there are specialists, both upstream on the R&D side and downstream on the implementation side, and they only get one route to earning profits. So before any entity decides to join an SDO, or if it's already a member of an SDO, before it decides to join a new standard development effort, the firms consider what their anticipated return on investment is. And if that's not positive, then they will not join that effort. Next slide, please. So SDO participation as a result will be impacted as the costs of participating, the costs of developing the new standard rise, or as returns fall. You can see participation in SDOs and in SDO efforts drop. And that's true for both innovators and implementers. And that has real world implications far beyond just the parties that are deciding to join or not to join. So if there's less innovator participation within an SDO or a particular standard development effort, you're going to see fewer new technologies contributed to the standard. You may see lower quality technology contributions as the entities hold back their most valuable, highest quality inventions to license outside of the standard so they can earn a proper return on it. And you may get fewer standards altogether if insufficient technology is submitted. On the implementer side, with less participation among the implementers, we can see lower competition in the downstream markets. And of course, both of these effects impact consumer welfare. They can affect prices of the products and services that are compliant with the standard, the quality and variety of the goods and services that are available. So getting the balance right between implementer and innovator matters a lot. Next slide, please. Just as a quick example, this is not just a theoretical economic construct, but we see these effects in the real world. This is just one example. We have a couple of others in our paper, but IEEE in 2015 imposed some pretty restrictive FRAND rules about how licensing of standard essential patents would take place for its standards. And immediately after the implementation of those rules, we began to see IEEE participants, members who have patents, beginning to opt out with so-called negative LOAs. That means that the letter of assurance didn't say, I'm going to follow IEEE's FRAND policy. It said, I'm not going to follow IEEE's policy. And so by mid-2019, last year, upwards of 77% of IEEE's letters of assurance for two very important next generation amendments to the Wi-Fi standard were negative. In other words, the majority were negative LOAs saying we're not going to follow IEEE's FRAND policy. And as a result, ANSI refused to approve these two standards. And moreover, just a month or so ago, the US Department of Justice issued an amendment to its original business review letter on IEEE's IPR patent policy and asked that IEEE consider changing its rules because it was not achieving the goal that it had set out to achieve. In other words, its clarity was not improved. It was actually more ambiguous now what was going to be FRAND and what was not going to be FRAND, and that their policy was out of step with current case law, at least in the US. Next slide, please. Just quickly so I can leave time for questions. There really is no such thing as a single optimal royalty base for every single case, every single standard, every single SDO. Because the patented technology differs across all patents, its use in different products differs, then every single evaluation is going to have to rely on the particular facts of the case. What is the SDO involved? What are the patents? Some patents are going to read very narrowly on components, and component-based licensing may make sense here. Others are going to really only be fully realized or fully valued when they're in the full product. In other words, there are interactions between different components, and so to capture the full value of that patented technology, you'd want to license at the end product level. So flexibility can be quite important, and it'll be a case-specific evaluation. Next, please. And so that means that court and agency interpretations need to proceed carefully. So I just want to conclude with the thought that because this flexibility can be so important in terms of getting the balance right between the implementer side and the SEP holder side, we want to make sure that courts and competition agencies around the globe don't overstep the contractual language of the SDO, what the parties have actually agreed their rules of operation are going to be. And when in doubt, license to all should not be imposed because it can have negative consequences, as I just discussed, on the quality, the quantity, and the prices of standard compliant products. And with that, I think we are moving on to the Q&A section.
Thank you very much for the presentation. And we have already a long list of questions. So let's get started with the first one. I think it is for you, Anne. It says, have the courts taken up the license to all issue yet?
The license to all issue, yes, they have. So there have been two very recent decisions, one in Germany and one in the Northern District of Texas in the US. And they have come down on the side of not interpreting the FRAND commitments at issue in those cases as requiring license to all, rather access. So the first one in Germany is the Nokia versus Daimler matter, where the court said that even if you were to license at a component level, the value of the technology had to reflect the full use in end products to OEMs of automobiles and to the makers of the components and to end users, et cetera. The case in Texas was, it was Continental v. Avanci, which Avanci is a patent pool covering 5G patents and their use in automobiles. And again, the court ruled that it actually was a motion to dismiss. It dismissed the matter that Continental had brought, and arguing that there was no foreclosure, no antitrust foreclosure, because Continental hadn't been licensed. It was still able to compete in the marketplace because a different point in the production chain was being licensed. So at least at this early stage, and it is very early, the first two rulings that I'm familiar with have come down more on the access to all side, but it's very early in the debate.
Okay. Next one is, I think, for Rick. What about other SDOs besides ETSI and IEEE?
Thank you. So I would say as to other SDOs, of course, back to what I said earlier, you really have to look at the particular policies at issue and the wording, the practice in the industry, the meanings of the terms involved. And I think one might easily come up with different answers for different organizations. But I think oftentimes you'll find that the licensing commitment is in terms of, it's written in terms of the patent holders asked to commit that it will grant licenses to practice the standard, which may be more like the ETSI sort of formulation that we looked at, that may be more directed towards end devices. And when you look at the practice in the industry, in some industries, that has been the practice for decades, and it would frankly make little sense at this point in time to come forward, to be successful with an argument that says, oh, what the policy actually requires is to license everybody up and down the chain, even though that's not what has been done over the past several decades. and it would not be something that that the patent holders participating in the organizations would have likely agreed to. They wouldn't agree voluntarily to a one-way ratchet that, going back to one of Ann's opening slides, that it really has the effect of driving royalty rates down to very low levels, and that's really, frankly, ultimately the point of the license to all argument, is to create this sort of one-way ratchet effect of driving royalties down. Looking at any contract, one has to look at what did the parties assent to, what did they agree to, and it's sort of facially implausible that they would agree to something where one party gets hugely disadvantaged. So those would be my general comments about looking at other policies. You have to look at the facts overall.
Okay, thank you. Next is this just a commercial dispute between firms? And why should an antitrust agency care? I think that's for Anne.
Okay. So yes, at one level, it is a commercial dispute. Just picking up on what Rick just said, the main impetus for pushing this license to all appears to be pushing licenses down to the component level, because then patent exhaustion kicks in. And of course, the prices for components are far lower. I think agencies and policymakers should care for the economic reasons that I closed out our presentation with, and that is that they have broad implications for the economy, for standard development ecosystems, and for consumers. And so if we want to maintain a healthy ecosystem for standard development, which has provided the world with tremendous benefits, too numerous to even list, then we have to make sure we're getting this balance right. And so we've already seen a number of agencies overseeing different SDOs' IPR policies. The DOJ has sat in on some meetings. I know the European Commission has guided ETSI and others as well. They can play a role in ensuring that the IPR rules are balanced, that it's not tipped one side or the other, so that we maintain these incentives for both parties to have strong participation. And then when it comes to courts, a lot of these things have to be interpreted. They aren't clear. They weren't really anticipating this kind of argument when some of these IPR policies were put in place at an SDO. And so they require some interpretation. And so I'm cautioning everybody to interpret in the side of flexibility that enables both component level and product level licensing as is appropriate for the facts at hand, and not to set any kind of blanket rules.
Okay. I will try to summarize several questions we received in one question. Is non-discrimination relevant to the question who is entitled to a license? I think that's for Rick.
Something that may well be, I think we both could answer aspects of this. And so from a legal perspective, I would say, look, non-discrimination is, in my view anyway, it goes to the question of whether similarly situated firms are treated similarly. And so if licenses are granted generally at a downstream level to device makers, say, and not generally granted upstream to component makers, then one would say the component makers are not discriminated against. They all are in, all the component makers are similarly situated, and they are treated similarly under that regime. And device makers are similarly situated, and they're treated similarly. So that would not be a discrimination issue. And I think that's consistent with the way that courts have so far been looking at discrimination at the ND prong of FRAND, for example, in Unwired Planet, in Sisvel v. Hire, in TCL against Ericsson. It's a similarly situated firms type of analysis. So I would say, in short, it does not really play into this issue. But I don't know if Anne may have comments as well.
Okay.
I would say economics supports the same view, because really what you're attempting to do from an economic perspective is to prevent distortions in competition, advantaging one party over another so that they can't compete fairly in the marketplace. Well, if you're not competing, if you're not a direct rival, then that's not an issue. So it's really about within the same level? Are you treating entities the same so that they aren't, the competition amongst them is not distorted? Across levels is a different question and not one for discrimination issues.
Okay, so two questions related to IEEE. One question seems to confuse the fact that there are contributions being made to IEEE for Wi-Fi 7, and the consequence of the negative LOAs. Could you please explain the difference?
So the contributions are technical contributions. These standard amendments, next generations of Wi-Fi, were in fact developed. So what you can see going on is parties who have inventions, they have patents on them, they contribute them to the SDO. In other words, they announce at the meeting, here's my technology, then there's an engineering discussion over whether that technology should be included in the standard. And that's a totally separate process. That's the standard development process. And then you get to the licensing. And so those entities who have those patents can then say, I don't like your IPR policy, IEEE, so I'm going to give you a negative LOA. I'm going to say, I'll license on what I think is FRAND terms, but I don't like your list of prescriptions. So I'm going to say, I'm not following your IPR policy, but I'm going to license on my own terms. And so, you know, you can have standards developed, but they didn't get approved by ANSI because there was just too much ambiguity over the LOA commitments. I hope that answers the question. I'm not sure.
I think it does. And another question suggests that there might be a coordinated opt-out of IEEE. What do you think about this?
I don't know. So coordination would probably be problematic from an antitrust side. I don't think that from an economics perspective, there would need to be coordination. It's not in many innovators' interest to follow IEEE's policy. So just of their own self-interest, they would issue a negative LOA. I think you'd have to dig into whether there was coordination amongst them to find evidence of that. I'm not aware one way or the other.
Okay. Okay. Thank you very much. I think we are about the end of the hour. So I would like to conclude. And to be honest, we have a long list of questions, and we definitely don't have the time to answer them. So as explained before this presentation, a recording will be made available on 4IP Council's website tomorrow, if not before. And the slides will be definitely made available very soon. Later today, you will receive an email inviting you to complete a 1-minute survey about this webinar. We will be very grateful for your feedback. So, and final is, I would like to thank you, Anne and Rick, for your very, very good explanations. I think it was very clear. And to conclude, I wish you all a very end of the day, and looking forward to talking to you at the next webinars.
Thank you for having us.
Thank you.